Good morning. I'm Michael Smith. I'm a lawyer in Marshall, Texas, and this is a post on my EDTexweblog, which deals with federal court practice in the Eastern District of Texas. This morning I'd like to talk to you about the post that you're looking at on your screen right now, which is a recent false marking case opinion by Magistrate Judge Chad Everingham of Marshall. Judge Everingham just issued an opinion in the Promote Innovation v. Medtronic case, which is 210 CV 233, on February 2nd of this year, recommending denying a motion to dismiss in that case. That case is kind of an unusual one. About 80% of the false marking cases that we see locally as well as nationally are simple cases involving just an expired patent. This case was a little different and was actually there were two cases like it at the December scheduling conferences before Judges Ward and Everingham in Marshall. And the situation in these cases is not one of an expired patent, but rather of a valid and enforced patent that has been declared unenforceable by a court. And the question is an unenforceable patent one that is unmarked for purposes of the false marking statute? Coincidentally, the patents in this case were declared unenforceable by Judge Ward about 2.5 years ago in the Medtronic versus Boston Scientific case that you'll see the cite to on the weblog post. On August 28th of 2008, Judge Ward found that the patents were unenforceable as a result of inequitable conduct before the Patent Office. So the question here is that declaring of unenforceability enough to make the patents unmarked for purposes of the false marking statute? Judge Everingham found that it was, citing primarily to an analogous case whose name I can't pronounce, begins with a P-E-Q, and he points out that this is similar enough to the analogous to what the Federal Circuit said in that case. Therefore, for purposes of the statute, this would be held to be sufficient for a false marking claim. Medtronic also sought dismissal on 3 other grounds. First, that it had marked with other patents. Second, that the patent was insufficiently that the complaint was insufficiently pled as far as intent to deceive, and third, that the statute is unconstitutional. He rejected those claims, pointing out the Fifth Circuit's opinion in Riley versus St. Luke's, holding a False Claims Act QI-TAM statute constitutional, and also pointed to the recent Eastern District opinions which have held that similar allegations regarding intent to deceive are sufficient to plead a claim under the statute, pending further guidance from the Federal Circuit. I hope you enjoy the post.